Good afternoon, ladies and gentlemen. As you are all aware that on Thursdays, the South African Bar Association hosts a program wherein we introduce a speaker who deals with a topic that is of interest to the profession. And this afternoon programs have well been received all around in relation to the practitioners and practice development. We thank you this afternoon for attending. I'm about to introduce a speaker today who's going to be speaking about the topic that is under labor law. We are having a guest today, ladies and gentlemen, Mr. Ali Ncume, Managing Director at Ncume Labor Consulting and an admitted attorney of the High Court of South Africa. He has completed his LLB at Nelson Mandela University, NMU, and served articles at Gravenstein Incorporated in Port Elizabeth, now known as Gabera. It is here that he gained valuable experience in civil litigation and developed a consuming passion for all facts of employment law. While pursuing his master's degree in labor law, Mr. Ncume involved himself in all aspects of labor litigation, consultation, and training. This was undertaken under the auspices of Gravenstein, as well as NMU Labor and Social Security Law Unit, who recognized this determination and superlative potential. Mr. Ncume is now in possession of his master's degree in labor law and has completed the relevant program in labor law practice, a course outsourced by NMU by the Commission of Conciliation, Mediation, and Arbitration, CCMA. In March 2015, he was appointed as a director in Masirumule Corporate Employment Law, where he was involved inter alia in consultation and training on employment law and employment relation, initiating disciplinary hearings, chairing disciplinary hearings and appeals, and formulating outcomes thereof, designing and customizing policy interventions and processes. In addition to his role as managing director at Ncume Labor Law Consulting, Mr. Ncume was appointed as a lecturer at the Department of Mercantile Law at Nelson Mandela University in September 2019. He's also a part-time commissioner at the CCMA and Education Labor Relations Council, South African Local Government Bargaining Council, and Safety and Security Sectoral Bargaining Council. Ladies and gentlemen, without further ado, I introduce to you our speaker, Mr. Ali Ncume. Thank you very much.
Thank you so much, Advocate. Hey, that was a nice intro. Every time I'm listening to people introducing myself, I'm like, it's a very nice intro. It's quite a mouthful, but a biography basically doesn't say much, because sometimes the biography sets a particular bar, and then when you actually engage with the person, you realize that whatever you heard is not actually what is the case. So firstly, I want to say thank you for the invite, and I want to apologize for my background because I am working from home at Gqeberha for the past 3 days. We haven't had water, so our water system is not working. I'm hoping we get water, so I've been working from home, hence the background is my lounge. So I am doing this in my house. As Advocate just mentioned, Advocate Romeo, that my name is Ali, my surname is Ncume. Ali is my full name, but a lot of people that they like to add things to my name. So some of my friends, they call me Ali Baba, or sometimes they call me Ali Cat or Ali Baha, but it's just Ali. My surname is Ncume, and I'm based in PE. I see myself as a labor law specialist. I assume that's why I'm here. So basically, we have 1 hour together, roughly 30 minutes or 35 minutes or 45 minutes, because I have to leave scope for question and answers. I want to highlight from the outset that I've never had this kind of a topic discussed in less than an hour. So it's the first time I'm doing it less than an hour, and I'm hoping that, within this time period I can be able to fit all the necessary discussions which I want to make sure I cover for the duration of the session. Now, the topic we are here for is basically things that we need to note when we are handling disciplinary hearings, and one thing I like about this topic is that this topic comes from the umbrella or the ambit of employment law. Now, in most workplaces, Every time people are talking about employment law, one will tend to realize, but sometimes in a particular workplace it's called employment relations. Sometimes in another workplace it's called industrial relations. So one thing I want to emphasize is that labor law, unlike all the other parts of fields of law, I'm talking about civil law, etc. Labor law is the only law which is based on a relationship. That's why whenever you apply for a vacancy, it is called employee relations or IR relations, because we understand that when we are dealing with employment law, we are focused on maintaining relationships. So if a disciplinary hearing falls within the scope of labor law, and labor law is about maintaining relationships, it follows that whoever is a relevant party or a stakeholder in any processes which has to do with labor law must always keep it in the back of his or her mind, but I am here to maintain a particular relationship. The reason I'm highlighting this before I start is because a lot of chairpersons, when they are invited to a disciplinary hearing, they've got this mindset, but I am there to deal with an issue. So we are always issue focused. There is an issue there, an employee committed misconduct, I must go there and deal with this issue. There's an issue there, an employee is not following instruction, I must go there and deal with this issue. And once we've dealt with that issue, most chairpersons are never concerned about what happens in the relationship between that employee and that employer. Parties are in your hearing room, you deal with the issue, you find the employee not guilty. What happens to that relationship? So we are so focused on the issue, but not on the relationship. Now, what I always advise when we are talking about employment law, owing to the fact that it falls under labor relations, employment relations, we must always make sure that whatever dispute we are involved in does not matter in what role or in what capacity, including be a chairperson, we must always understand, but we are here to deal with an issue and maintain the relationship. So how as a chairperson do I address the issue and make a finding, but at the same time simultaneously making sure that the relationship between the parties after my involvement is left sound and fair. So a lot of people have forgotten that principle. Before I put up the presentation, another thing I want to highlight is that we must never forget the meaning or the title of the topic. How do we handle disciplinary hearings? Now, in our labor law, we have various types of hearings. We have grievance hearings. We have incapacity hearings. We have performance hearings. We have disciplinary hearings. So if we are here to discuss disciplinary hearings or how we handle those kinds of hearings, the first thing we need to remember or make sure we are mindful of is that there can never be a disciplinary hearing without an employer enforcing discipline. And the only time an employer can enforce discipline is if the employer is dealing with a misconduct issue. So a lot of employers invite us on hearings, and they call this hearing a disciplinary hearing. And then when you get to the hearing and you're looking at the charges, you realize, but this employee in fact is charged for poor work performance. But poor work performance is an incapacity issue. And for incapacity issues, we're not allowed to enforce discipline. We don't discipline for incapacity, we discipline for misconduct. So us as chairperson, we always need to draw that line back, and we always have to satisfy ourselves that we are dealing with a misconduct issue, because incapacity is a no-fault-based dismissal. Incapacity is when we have an employee who is failing to perform because this employee has never been trained, has never been guided, has never been assisted. So we don't discipline for incapacity because you cannot discipline someone who is not at fault, because it's classified as a no-fault-based dismissal. So the only time we are invited to hearings and we see that is called a disciplinary hearing, we discipline people or we involve in disciplinary hearings, because a disciplinary hearing is when an employer is dealing with someone who committed misconduct. So what is important is that we always have to make sure we can differentiate between misconduct and incapacity. Because a lot of employers still don't understand the difference. And as a chairperson, you cannot involve yourself in a disciplinary hearing for issues which has nothing to do with misconduct. Practical example, just imagine an employer taking an employee to a hearing saying, charge 1, his job has become redundant. We know that's an operational issue. We know that's a retrenchment issue. We can't be in a hearing for a job becoming redundant. So we need to make sure from the outset, but this hearing is for the correct purpose, meaning someone here is being disciplined for misconduct. Emphasis on the word disciplinary hearing. We are disciplining someone here. And you can never be disciplined as an employee if you are not at fault. That's why for retrenchment, there are no hearings, because it's a no-fault-based dismissal. There's just consultations. That's why in incapacity, there's no disciplinary hearings, there's incapacity hearings, because it's a no-fault-based dismissal. The only time we have disciplinary hearings is when we are dealing with a fault-based dismissal, which means we are dealing with a misconduct issue. So we need to make sure we understand that and we are able to visualize that. If I'm invited in the hearing as a potential chairperson, I am invited to a hearing which has to do with the misconduct issue. Employees discipline, misconduct. Warnings are issued for misconduct. So misconduct is the only issue which takes us to a disciplinary hearing. Other hearings, incapacity hearings, is for other issues, but for discipline, misconduct. Now, since we have identified, but okay, as chairpersons, we can be invited to misconduct issues which are going to be dealt with in a disciplinary hearing. The second thing we need to make sure we understand before we start the presentation is that only employees can be disciplined. For those who don't understand, you see, a lot of people underestimate that statement, that only employees can be disciplined. I mean, if we are talking about labor law and discipline comes from labor law, it basically means we are maintaining the relationship between an employer and an employee. The only parties who can be involved in a disciplinary hearing is an employer and an employee. So just imagine you are invited to a hearing and it transpires that the person who is charged is a freelancer. The person who is charged is a subcontractor. The person who is charged is an independent contractor. Employers have no discretion to discipline anyone but an employee. Only employees can be disciplined. Only employees can be suspended. Only employees can receive warnings. Only employees can be retrenched. Employees can challenge issues at the CCMA. Labor law is about employees and employers. So we can never be able to comment or start a hearing without understanding or being satisfied that we are dealing with an employee. There was an interesting case I was involved in. Since this is a labor law, it's a session, you know law, where an employee applied for a job. This employee, a job applicant applies for a job and she goes to the interview. The way that she was so successful in the interview, the prospective employer says to her, there's no way I can let you go. Here is your contract. Sign now. I want you to sign. This person signed the contract. But in the contract, there was a clause which says, she signed it on the 1st of March. 1st of Feb. She ought to start on the 1st of March. So she had 1 month to plan her stuff and resign where she was currently working. Obviously, now when she's anticipating the new job, she files a resignation with the old employer. But hey, it's my last month. I'm leaving a globe now. Come roughly 25 Feb. 3 days before he or she starts the new job, it was a he, before he starts the new job, he gets a phone call from the new employer. And the new employer says to this person, but Funny, this job you're supposed to start on Monday is no longer available. Now this person obviously felt aggrieved. He's like, I resigned where I was working. How can you do this to me right now? What am I supposed to do? And according to this person, he felt as if this new employer is dismissing him. But hey, you're dismissing me most now. And the employer's argument was simple. Funding, only employees can be dismissed. You are not my employee yet. And this guy's argument is, no, what do you mean? I've signed the contract. By signing the contract, I became your employee. The employer's argument was, you haven't worked for me. You haven't gotten paid by me. You haven't even showed up at my office. That basically, you're not an employee. So there was that dispute about whether or not the person was an employee. So the reason that dispute had to arise is because this person was seeking a remedy in labor law. And you can never have a remedy in labor law unless you have proven that you are an employee. The same principle applies when we are enforcing discipline. Only employees can be disciplined. That's why the potential chairpersons or people who are currently chairpersons, it's very important that we identify the parties from the outset. In our hearing room, we have to make sure we have an employee because only an employee can be disciplined. That's why in our legal framework, on all legislations dealing with employment law, there will always be a definition of the word employee because it's a very important definition. It tells us to whom the law applies to. So we always have to make sure we are dealing with employees. Now, what I'm going to do as a starting point, I mean, some of you might see this as irrelevant because maybe you practice labor law, but I'm going to put up the Labor Relations Act quickly. And the basis of putting up the Labor Relations Act is quite straightforward. I just want someone to please make me a presenter because I can't put up the act. But one thing, the reason I want to show you the act is because in the act, the definition of the word employee is straightforward. And owing to the fact that labor law was drafted for vulnerable employees, because employees are vulnerable, there's not too much technical language. And if you look at the definition of the word employee in the Labor Relations Act in particular, it's quite straightforward. An employee is the person who works, who gets paid, who assists in the business. I mean, those elements are there, you see. So once you've identified you are dealing with an employee, then you are satisfied that the parties before me are the parties who have to be in the disciplinary hearing. And this is happening before you commence the hearing. So what I normally do in the hearing, when I start the hearing, remember, colleagues, we can never conduct the hearing in the same way. You know, maybe you have a different start to the hearing. I start my hearing different. For example, what I normally do, besides all the other steps I get to a position when I ask the person, so do you work for the organization? Yes, I work for the organization. Are you a freelancer? Are you permanent? Are you in a fixed term? What type of job are you doing? No, I'm a permanent employee. So you get a salary from the employee? Yes, I do. That time I am busy ticking the boxes that I am dealing with an employee. Just imagine you write an outcome or a finding in a disciplinary hearing, but your outcome is based on someone who is not an employee. You are issuing a sanction towards an independent contractor. So we can never draft judgments for independent contractors. It's for the same reason that independent contractors can't refer unfair dismissal disputes to the CCMA or bargaining council, because they are not employees. So those are minor things that we always have to make sure we deal with before we start the hearing. It's what people will normally refer to as preliminary issues, but not in a technical sense. So preliminary issue number one, am I dealing with the misconduct issue? Preliminary issue number two, is there an employee here? Because remember, an employer can only discipline an employee. You know, so that is a tick box exercise. Now, once we are satisfied about that, it's a pity I can't share my screen. I hope someone is sorting that out. Once you are satisfied by that, one thing I also want to raise, we must always be mindful of the fact that chairpersons are organized by employers. The person who's going to pay the salary of the chairperson is an employee. In order for the chairperson to be invited to the hearing, the employer is going to phone the chairperson for that situation. Thank you. I can share now. The employer is going to phone that chairperson. The chairperson is phoned by the employer. The chairperson is paid by the employer. There are discussions before the hearing between the employer and the chairperson. So from the outset, by being the chairperson, the employee who is being disciplined in the hearing already has a perception of being biased, that the chairperson is going to be biased. Obviously, if you see me in a hearing, hey, this guy is here to chair my hearing. Hey, who organized this guy? The employee. Who's going to pay this guy for these services? The employee. Hey, was there a conversation before you were appointed? Yeah, the employer phoned me. So employees already have this perception, but chairpersons in general are biased. They always create a perception, but they're going to be biased. That's why, as a chairperson, when we are about to get involved in issues of chairing disciplinary hearing, we must try by all means to minimize or limit any perception of being biased. It might seem as if it's not a serious issue. I never arrive at the hearing early. The reason I never arrive early in the hearing is because if I arrive early and the employer party arrives early and the employee is not there, it basically means I'm going to end up inside the venue with the employer party. Just imagine the employee now arriving to the hearing, he finds me or she finds me sitting with an employer having a conversation. What are we talking about? I mean, we might have been talking about something which has nothing to do with the case, but from the employee's perspective, hey, this guy who has to decide my case, I arrive at the venue, he's sitting with the initiator, they are having a laugh. Those small things create a perception of being biased. Remember the hearing, it's there to tick the box of procedural fairness. And whatever happens in the hearing might be challenged when the employee is challenging the procedure. So we don't want to make mistakes whereas we make an employee feel as if you're going to be biased. The way you greet the employer, hey, good morning, Michael. Hey, Steve, how are you? When you greet the employee, hello, employee. The manner you greet, employees are thinking, I mean, I deal with these cases on a day-to-day basis at the CCMA. The employee is thinking by, hey, advocate Golfin, and you Mr. Golfin, how can he shake the hand of the employer when he's greeting the employer, but when he has to greet me, sharp, Ali? The way who you greet first creates a perception. Who do you have a tea break with? Maybe the hearing is a full day hearing. You say to the initiator, is there any coffee around? The initiator says, yeah, the coffee is in the kitchen. You leave with the initiator. The employee is witnessing this. The sitting arrangement in a disciplinary hearing. You are sitting here, line manager is sitting here, the employee is sitting across the table. There's no equality. Everything seems as if it's unfair. So those are things which are administration issues where we always have to make sure we don't create issues in those instances. So it's either you arrive in the hearing when you have to start, or if you arrive early, no one is supposed to enter the hearing until both parties are here. It's a different story if the employee is late, because then the employer would have entered the venue because the starting time arrived. We can't be having side caucuses with the employee. We can't be involved in situations where the employees feel as if we're going to favor the employer. So we remove all those things. If we are greeting the parties, you know, what I normally do, I just say, good morning, parties. I don't say, good morning, Steve, good morning. I don't want to create the perception by, hey, this one is getting so and so fast. It might seem as if it's minor issues when we're thinking about them practically, but when process is challenged, it becomes a major issue. You know, there was a case I was dealing with yesterday where the employer of the company thought the hearing was going to be chaired in the chairperson's building, but it was on a chaired in his premises. He went to the chairperson's company. When he get there, the employee is waiting on the venue. He drove with the chairperson from the chairperson's office to the venue. How that small issue, you are sitting with the chairperson, you are in the same car with the chairperson who has to decide my case, and you are arguing the case for the employer. Those minor issues, we don't want to involve ourselves in those things. Some of us as chairpersons are going to be tempted to execute mandates. I mean, we are working for money. We want to get paid. I mean, we invoice. You know, after this session, I'm going to submit an invoice now to all my guys. We invoice. We work for invoices, you know. And sometimes when the clients who are going to be calling us or instructing attorneys, advising us to come chair hearings, they always drop a hint in between the phone call. Mr. Mahlangu, advocate, I've got this employee, man, for the hearing here. This employee is annoying me. I want him out, full stop. That want him out, he gives you an idea of what your client wants. I emphasize, it's your client that You are invited to chair a hearing of your client. Now you've got two options as the chairperson. It's either you're going to follow a fair process where you're going to evaluate all the evidence, or you're going to be a chairperson who's going to be following mandates. There are so many chairpersons, irrespective of what the employee says in the hearing, just to make sure that they maintain the relationship they have with their client. They find the employee guilty. We don't want to be caught up in those situations. So those are minor issues. We're avoiding perception of being biased, etc., etc. And obviously, we make sure parties are comfortable. There's equal sitting in the venue. You know, we've satisfied ourselves. We are dealing with an employee. We are ready. Never chair a hearing where you've been involved in investigating the matter. You know the facts. What is the purpose of opening statements in the process? Why, when we go to forums, the magistrate or the judge or whoever, the commissioner, will say, what are your opening statements? The purpose or the rationale behind opening statements is to introduce the chairperson to the facts of the case for the first time. Otherwise, if chairpersons knew the facts before the hearing and they knew what happened, there would not be a need in a disciplinary hearing to have a stage which deals with opening statements. So we need to make sure we accept the instructions. For example, in my office in PE, I was involved in an investigation for one of my client matters. They had a hearing. They asked me if I could chair the hearing. I said to them, but listen here, I was involved in the investigation, but my partner who is sitting in that other office has never been involved in this matter. So he can chair the hearing. It's still my company, but someone else, because I am removing any perception of being biased. I want to enter the hearing with an open mind, you know. So when I facilitate these trainings, colleagues, I normally use a manual, you know, and unfortunately, I'm going to focus on a particular part of this manual, just it's a manual I use with Maseremule, Puke, Maseremule, and Maseremule in Cape Town, because I'm still an associate there. So what normally happens, I've realized, but actually in a hearing, there are 12 steps, you know, and all we have to do is make sure we comply with the 12 steps. And sometimes in the hearing, you know, we've got these qualifications, you know, we are advocates, you know, we've done our privilege, we are in the bar, we've got this thing, but we are expected to know everything, you know. When I started chairing hearings, I used to have a key ring with a card on my chest with all the steps. I used to read those steps every time in my hearing. I used to look down on my card and I'm like, okay, I'm doing this now, I'm doing that now, I'm doing that now, I'm doing that now. And even when I joined the CCMA, I joined the CCMA at a very young age. Right now, I'm 30 years old, 31, and I joined the CCMA, I think I was 21, 22. You know, but when I joined the CCMA, I did not know the processes. I also had cards, you know, I was looking at the cards, hitting the cards, you know, etc., etc. You know, so we need to understand, but this process, number one, is not cornerstone. You know, it's not cornerstone. Remember procedural fairness in labor law. Procedural fairness, the only requirement on procedural fairness, insofar as the hearing is concerned, is that the employee must be given a chance to state a case in response. There is nothing in procedural fairness which says there must be opening statements, there must be evidence stage, there must be closing arguments, there must be sanction mitigation. Those things are not true procedural issues. Procedural issues are simple. Make sure you give an employee a chance to state a case in response. Make sure you give an employee an opportunity to be represented, etc. So those are true procedural issues. So despite the steps we're going to focus on, it does not necessarily mean we must tick all those boxes. It's impossible. We facilitate trainings in a different, hearings in a different manner. Step number one in a hearing, which I normally follow, which is quite simple, is normally the introduction stage. Step number one is presence. You know, I had an arbitration, I think a few years ago, in the bargaining council. I think it was MIPCO, metal industry, bargaining council, whatever, engineering. And there was someone who walked inside my arbitration room. And when he walked in, I was quite convinced about, okay, it's his case. And then the employer walked in, hey, I ran the arbitration, you know. And the employer the main employer was not there, the representative was there, like an employer's organization. So during the arbitration, this guy says to me, hey man, the employee, and I don't think this case is for me. I hear you are talking about theft. Yeah, me, I was not dismissed for theft. Me, my case is about late coming. Hey, I asked this guy, I didn't do introductions. I haven't even, what I normally do sometimes, you know, well, what I used to do, if I'm chasing time, let's say I'm looking through my file, I don't have a register. I normally say, okay, guys, I will ask the CMO to bring a register. Let's start so long. And then I start. You know, this guy introduced himself, but the employer representative, because he doesn't know who the employee is, he's only here to represent. He does not even know if this is the correct employee or not. I ran the arbitration for like 20 clean minutes, and then it transpired, but this party is in the wrong hearing room. You know, it's a mistake that will never transpire in a world-class part. Sometimes, due to unfortunate circumstances, it might happen. So we need to make sure we've got the correct parties in our hearing. Is the employee here? Is the employer representative here? Is there someone from HR who is here? It's quite important for us to have people from HR in the hearing. The reason I'm saying that is because as a chairperson, we are invited to companies we've never experienced on, or we've never done any work for them. So we don't know what their process is internal. There are some workplaces where employers don't go to a hearing to issue a warning. There are some workplaces where an employer goes to a hearing to issue a warning. So just imagine you attend a hearing and you ask the employer, are we here for a warning? We're not supposed to be here because we are used to a process which happens in another company. Only the HR people can assist or guide us with their HR processes. So the HR is not normally there to lead evidence. The HR is there to observe, to make sure that we comply with the process applicable in that particular workplace. So for example, when I ran the hearing and I ran the hearing and the HR person says, Mr. Ncume, I see you've closed the introductions. Can you please ask the employee if he's going to call any witnesses? Because in our process, we have to ask that question. Guiding the process. Okay, thank you, HR. I did not know that's part of the process. Employee, so we always need HR to be there. But we must be careful as chairpersons. HR in a disciplinary hearing cannot wear two hats. You can't be a witness and be an observer at the same time. Because a witness in a disciplinary hearing cannot sit inside during the evidence stage. A witness must be outside. So an HR person who is going to be a witness cannot be sitting inside from the start to the end of the process. Excuse me. Because witnesses sit outside. So it's very important we confirm the capacity upon which the HR person is attending. HR, are you here as an observer? Or are you here as a witness? Are you going to be testifying? No, I'm observing. Okay, fine. So you're going to take minutes. Should you see we are going off the process, please let us know, etc., etc. We've got the employee. We've got the employee representative. In most workplaces, that's likely going to be a fellow colleague or a trade union representative. I emphasize a trade union representative, which means a shop steward. A shop steward only comes from a recognized union in the workplace. An employee can't be bringing a shop steward of a different company to my company. So sometimes employees, they take this charge, hey, let me go join a union, and then, hey, can you give me a shop steward and come and argue in my case? When it comes to representation, remember, trade union representative shop stewards are recognized only in terms of Section 14 of the LRA. And to be recognized, you must be a recognized union in my workplace. So which follows that we're talking about a shop steward which works here. The employer party is here, initiator, and then obviously we have whoever, okay, the HR. So those are the general parties, you know. And now what I normally do in my introduction, I know, especially if I know I am popular in a particular workplace. Practical example, if you go to a particular workplace, let's say one of my clients, I am there almost every week. So employees see me coming in, coming out, coming in. So they see me, hey, this guy is the lawyer of this company. Now, when they see me in the hearing, they're like, hey, it's the lawyer of this company, most this. So sometimes what I normally do, I normally ask the parties, but hey, is there any objection towards me being a chairperson? Is there anyone who objects? I know you might have seen me around here. I know you see me coming in here, but is there any objection you have towards me being a chairperson? Do you feel as if I might be impartial? If so, what are the reasons, so that I can listen to your reasons and make a ruling to that effect? I am not saying us as chairpersons, we always have to recuse ourselves when someone makes an objection. It must be a valid objection, but we have to entertain objections. We are avoiding procedural disputes which might come from perception of being biased. In the event the employee is lodging a dispute after this hearing and says the chairperson was biased, your argument as a chairperson, but I asked you before I started, do you have any objection to me being a chairperson? And you said no. Now we are sorted. We know the parties. We know who is here. We know in what capacity HR is here. We know there's no objection. The first thing we need to confirm, are we here for misconduct? Remember what I said. We can't be chairing hearings unless we know what the charges are. And the moment we pinpoint by, hey, these charges are actually incapacity related, we're not supposed to be here. Because remember, chairpersons, the evidence you hear in a misconduct dispute is different to an evidence you will hear in an incapacity dispute. If we are dealing with an incapacity issue, you want to hear, was the employee trained, was the employee assisted, was there any counseling, was there reasonable time to improve, were the performance improvement plans? That's the evidence you're expecting in an incapacity hearing. In a misconduct hearing, the evidence you expected to hear, was there a rule? Was the employee aware of the rule? Did he contravene the rule? So it's very important we identify where we are. That's why it's quite important that before we start the hearing, we are certain of the charges. Initiator, what are the charges leveled against this employee? The initiator obviously now read the charges. Just imagine that initiator says, chairperson, Ali, despite giving him chances, we have realized he doesn't know how to draft heads of arguments. You've realized he doesn't know how to draft heads of arguments. Yes. Can he or can he not? He can't. Remember, incapacity. You want to do the job, but you can't. Misconduct. You can do the job, but you choose not to. So if someone says, we appointed Ali, then he can draft heads of arguments, we just realize why he can't, so we charge him for not being able to draft. So that is an incapacity issue. Because this guy does not know how to draft heads of argument. He's never been trained. There's no false element on his part. We can't be in a disciplinary hearing for that. So that's why people never understand the rationale behind reading the charges before we start the hearing. We are trying to identify, are we here for a true misconduct issue? The charges are read to the employee. You know, I wish I had so much time, but I'm concerned about time. But this is also the step which makes us identify as chairpersons if there are any duplication of charges. Because sometimes employers, what they do, they duplicate charges. Practical example, I'm going to try and make sure, colleagues, I stop at 10 to, and then we do questions. Practical example, let's say my employer says I must draft heads of arguments by tomorrow. I don't draft them. And now he wants to discipline me for that. He can say, charge number 1, insubordination. I asked Ali to draft heads of arguments, he did not. And then if he goes down, if he scrolls down to our rules, our code, disciplinary code, he might see something called failure to follow instruction. Then he's like, hey, this thing Ali did is also failure to follow instruction. Charge number 2, failure to follow instruction. I asked you to type heads of argument. You did not. Then he goes down the code and then he sees the relation of duties. He's like, hey, this thing Ali did is also the relation of duties. Charge number 3, the relation of duties. I asked you to type heads of argument. You did not. Then he scrolls down the code. He sees negligence. Hey, this thing Ali did is also negligence. Charge number 4, I asked you to type heads of argument. You did not. You were negligent. But when the employer is leading evidence to prove these charges, to prove insubordination, he's going to take out that email. I sent Ali this email to draft. He did not. To prove the relation of duties, he's going to take out the same email. I sent Ali this email to draft. He did not. The election. To prove failure to follow instruction, he's going to take out the same email. I sent Ali this email. He did not do it. He failed to follow instruction. To prove negligence, the same email, whenever an employer is relying on the same evidence to prove different charges, that employer is duplicating the charges. We can't charge an employee 4 times for one conduct. So what I'm trying to highlight is that in some instances, an employee's conduct, one conduct, can break a number of rules, but an employer must choose one primary charge. You know, so sometimes employers duplicate. Don't get me wrong, there's nothing preventing an employer from charging in an alternative. An employer can say charge number 1, insubordination. Alternatively, failure to follow instruction. Alternatively, the election of duties. Those are alternative charges. If an employee is found guilty on one, all the others fall away. Alternative, I'm charging you for this or that, or that, or that. Unlike duplication, where I'm charging you for this and this and this. So when the employer is reading the charges, as a chairperson, you must be mindful. But hey, sometimes you read the charges like, hey, what a charge number 1 and charge number 2 are saying the same thing. And if it is, you must pose that question, employer, what is the difference between charge 1 and charge 2? Because to me, it seems as if it's a duplication. And if it's a duplication, one of those charges must be struck off. Employers are not allowed to duplicate. Now, there is 2 possibilities. We all know this. That can happen in the event that the employee now is asked to plead to the charges. The employee can plead guilty. The employee cannot plead guilty. Sometimes employees, they say, I don't want to plead, full stop. Now, in our labor law, if an employee doesn't want to plead to the charge, automatically we enter a plea of not guilty. Automatically, you know. And even if an employee pleads partially, sometimes an employee can read the charge and say, Mr. Chairperson, this first sentence on the charge, I agree with it. But this second sentence, I don't agree with it. So I can say guilty to the first one, but this one, I don't. So the employee is pleading partially. I plead guilty to the first sentence. No, we can't have employees who plead partially to charges. We can't have employees who don't want to plead. If you don't want to plead, enter a plea of not guilty. If you plead partially, not guilty. Sometimes an employee pleads guilty. And chairpersons, they laugh it when an employee pleads guilty. Because if an employee pleads guilty, there is no obligation on us as chairpersons now to listen to the evidence. Because the purpose of entering the evidence stage is to establish the finding of guilt. So if the employee says, I am guilty, some chairpersons are like, okay, he's guilty. Okay, fine, full stop, he's guilty. Sometimes we have to satisfy ourselves to the plea. Are you sure you are pleading guilty? Did anyone coerce you to plead guilty? Was there any force or compulsion or agreement you concluded? You know, there was a hearing where an employee said to me, the initiator said I must plead guilty because if I plead guilty, he's going to make sure I get a warning. I'm like, So on that instance, I felt as if the employee pleaded guilty because there was some form of coercion. So I said, okay, fine. In that instance, we are entering a plea of not guilt. So if an employee pleads guilty, satisfy yourself to the guilt. Make sure you are satisfied that the plea was done voluntarily. Remember, if the employee pleads guilty, no need for evidence. But if he pleads not guilty, that's where we explain the hearing process. Guys, employees, most of the time, are facing well-skilled people in disciplinary hearings. Just imagine being in a hearing, you're an employee, you are facing an HR representative. You've never been on labor law issues before. This employee is scared. He sees or she sees himself as inferior. I was in a hearing last week where an old lady, all she was doing during the hearing was, what that? Hi, Dad. What that? She could not even look at me in the eye. And I'm sitting there, and the HR person is throwing legal positions, and this lady was, hi, Dad. Hi, Dad. She was scared. So we will always have to make sure wherever we are, remember labor law, managing relations, we are endorsing the principle of social justice. We have to explain to employees what they should expect. Listen, dear employee, this is a hearing now. You pleaded not guilty. I want you to make sure you understand what's going to happen in this hearing. Obviously, if the employee is Xhosa speaking or Afrikaans, there's an interpreter here. I want you to come down.
Mr. Ncume.
Yes.
I think we are going to actually suggest that you are going to continue with the presentation again next week, because looking at the time, I don't think that you are going to be able to continue to finish. So I think now let's open the floor for question and answers, and then whatever you have not completed, you will continue with another 2 hours next week, so that at least we will be able to cover all these things.
Yeah, that's fine, advocate. We I get excited when I do this stuff. Just to wrap up, it's fine. We can continue next week. Remember, we're on step number 3. We are explaining the process. So when we come back next week, we are continuing from step number 3. And then I will try by all means when we start on the next session. I use the time wisely, you know, these things become quite interesting. So we can take a few questions if there's time for questions. Advocate, over to you.
Thank you, Mr. Ncume. I will want to allow questions from our guest. I recognize the hand of Advocate Bartford. Please just switch on your camera and unmute yourself. Thank you, Advocate Ford.
Thank you so much, Advocate Ntambeleni, and to our speaker, Mr. Ncume. I think the question I have is one more to do about the integrity of the disciplinary process. It strikes me in terms of my experience often that the disciplinary process is really a smoke screen and a superficial process to follow through on a decision that an employer has already taken. But in order to meet and tick the boxes of the Labour Relations Act, the employer goes through it, but it's almost as if the employee's fate is already predetermined. And as counsel, I have found in instances where I have been called to chair hearings, where I found an employee not guilty. That's the end of the stream of work coming to me. And often the impression that I labor under is one might feel confronted by the fact that if you were to make a decision which is against the employer, well, that is effectively cutting your nose to spite your face, because you're never going to get any work from an employer out there after, because you found against them. And that's a real difficulty. And I think for me, that's where I'm speaking about the credibility of the process. Now, I can list, and I don't have the authority to do so, a number of companies where I've chaired hearings, found employees not guilty, and that's the end of the stream of work. And I'd like you to perhaps to comment on that and to perhaps share some of your experiences in order to ensure that the delegates who attend need to know they must, as Shakespeare says, to your own conscience be true. Thank you.
Thank you, Advocate Ford, for that question. You know, exactly what you've stated is what it is. Unfortunately for chairpersons, you know, what if we get instructions to chair hearings, this is our livelihood. That's why now in some instances, a chairperson now gets conflicted. We have chairpersons who are so focused in maintaining the relationship they have with their client rather than focusing on the ethics or the norms or your beliefs or the morale of being a chairperson. Remember, at the end of the day, we must not forget we are in the legal fraternity, which basically means the conduct we do is always driven on morals and ethics. So you need to ask yourself, and me, I don't condone following mandates. You know, we need to stand there and we need to make sure we draft findings which are fair. Remember what's going to happen in the event the employee challenges your procedure or how you got to your decision as a chairperson. You are going to be called. If the matter is going to the CCMA and you are needed to come and testify, you need to report how you got to your decision. Just imagine now a situation where at the CCMA or a bargaining council, the commissioner says, no, Advocate Ford, you know, you did not apply your mind. That affects your credibility. That affects your reputation. It makes you look not competent. We don't want to involve ourselves in situations where we limit our professionalism just to favor clients. You know, so generally in practice, if you rule against the client, unfortunately, that relationship between you and your client might come to an end because you did not execute the mandate. But it's rather to follow your ethics and to follow the law rather than following a client. And to go back to your second point, that it seems as if a hearing is already predetermined. I also agree with that. You know, that's why employers in hearings have tick boxes. The introduction, it's a tick box exercise. But our legislators, they knew employers would use a hearing as a tick box exercise. That's why when the matter comes to the CCMA or bargaining council, the hearing is viewed as a de novo hearing, because now at the CCMA, no one has a relationship with an employer. It's not a chairperson of the employer. This chairperson there doesn't know what's going on. He cannot be following any mandate. So the hearing in de novo means that internal hearing starts over as if the first one never took place. That's why we have that step, because it has been seen in our law, but employers internally, they don't use the hearing for its purpose. So to make sure we push them towards using the hearing for what it was intended to. If they come to the CCMA, it's a hearing in de novo. That hearing starts afresh. So when that hearing starts afresh, there's no more mandates there. So that's what a hearing in de novo was carried for, to try and attack that. But generally, wherever you go, an employer has made the decision before you even chair the hearing, you know, and they are waiting for that outcome, because some chairpersons then, to make sure they maintain the relationship, would accept and follow that mandate just to get that money, and which is very unethical. I don't condone that. Thank you, Advocate Ford. Any other question? Okay,
there's a question that is on the inbox, and then the question is asking a very important question. It says, what happens when the employer or a chairperson fails to deliver a judgment within the prescribed period of time? What is the effect of the disciplinary hearing, and what is the remedy for the employee? So what happens when the employer or the chairperson fails to deliver judgments within the prescribed period? What is the effect on this disciplinary hearing, and what is the remedy for the employee?
Okay, yeah, no, that's fine. Yeah, it all depends on the circumstances, number one. Now, there are some employees who are on precautionary suspensions while we are conducting the disciplinary hearing. I've been suspended. Now I went to the hearing. I'm still on suspension. Now I am waiting for the outcome. So remember now, the issue of suspension, a suspension can become unfair depending on the duration of it. Although our law has never dictated how long a suspension is, but if an employee feels as if, hey man, I'm waiting for this outcome, I'm on suspension, I don't know what's going on, it's 3 months down the line, that employee can have a remedy where that employee can lodge an unfair labor practice dispute related to the suspension, but the duration is unreasonable. I feel as if my suspension is unfair. So that's the route that someone who is suspended can take. Now let's see someone who is not suspended, but now this person now is waiting for the outcome. Remember, that also depends on the sector upon which the employer falls under. Remember, in our law, we have a private sector, people who regulate their own contractual terms. We have people who have unionized workplaces where there is collective agreements. We have sectoral determinations, you know, which prescribe other terms. Generally, in our law, there is no period prescribed for a chairperson to issue an outcome. There is nothing in law which says after the hearing, the chairperson must issue an outcome by this date. The chairperson normally dictates the period upon which he would issue an outcome. And unfortunately, you know, sometimes the matters are so complex that the chairperson needs time, but that chairperson is likely to correspond with the parties, but I'm still busy, I'm still busy, I'm still busy, I'm still busy. But if the outcome does not come out in time and you hear nothing, you must ask yourself as an employee, how are you prejudiced? You are still at work, you are still getting paid, you are still not found guilty. So although the outcome has not been finalized, you know, it does not necessarily mean that you are prejudiced. But okay, there's a follow-up question. It says 5 days in terms of the resolution, state execution. Which means there's a collective agreement which says 5 days, you know, there's a resolution which says 5 days. Now, remember in our law, there's a dispute which is called interpretation and application of collective agreements. A resolution, for example, in the education sector, we've got a PEM resolution. Resolutions are collective agreements. So if there's a collective agreement which prescribes a period, now the employer is failing to apply that period. That is an application dispute. So you can refer a dispute for the application of the collective agreement. And then the CCMA or the bargaining council, depending on which sector you fall in, might issue an award saying, bah, the 5 days ought to have been applied. We're giving the chairperson 3 more days, he must issue the outcome. I don't think the law is open to the extent, but since the 5 days is late, the outcome must fall away. I don't think it's strict to that extent, but just because 5 days is missed, it means now I'm on a clean slate. No, because the law, man, it would be a bad proposition to propose that. Maybe there are valid reasons why it's delayed. You know, maybe the chairperson encountered an illness, COVID, we have no idea. But provided that there is a valid reason which can be explained to the council, even though that 5 days was contravened, the council can issue a directive. But chairperson, it's late. You fail to comply with the collective agreement. We're giving you 7 days. We want that outcome out. And then that will be a directive. So you will probably refer that dispute. I think that was the second question, Advocate. I'm not sure if there's any other questions.
I have a last question that I want to ask myself in relation to incapacity, and then I wanted to check with you. What is your view relating to people that refuse to vaccinate and they're dismissed based on incapacity? Because in my view, refusal to vaccinate does not make you incapacitated. You just explained now to say that incapacity is when you are unable to perform your work and your duties, but these people are dismissed on the basis of incapacity, and then that is my question.
Yeah, thank you, Advocate. It's a tricky question. You know, at CCMA we are dealing with vaccination cases. They are new, but the bottom line is quite straightforward. Remember, there are 3 valid reasons to dismiss an employee: misconduct, incapacity, operational requirements. Now, it's quite obvious, but for example, if you are dismissing someone for failing to vaccinate, you can't put that under operational requirements, because for operational requirements, I'm saying your job becomes redundant, which means I can't replace you. But if you are dismissing someone for vaccination, you're going to replace that person, so operational requirements fall away. Now, let's go to incapacity. Incapacity is based on performance. You can't perform because you don't know how to do the work, or it's based on an illness, or it's based on an injury. So now we have an injury. There's no injury here. There's no illness here. And it can't be poor performance because you are performing, And then we go to misconduct. Can it be misconduct? Now, the Advocate, we must think broadly. If the employer introduces a mandatory vaccination policy, now it's a policy, this. And remember, in the workplace, employees are obligated to follow workplace policy. And now the policy says everyone in the workplace must be vaccinated. In the event you fail to comply with that policy, it basically means that now you are contravening the policy. And contravening a policy, sometimes people can classify that as misconduct. If we have a sick leave policy which says to apply for sick leave, you must do this and you don't do it, it's misconduct. If we have a policy which says don't come to work intoxicated and you come intoxicated, it's misconduct. If we have a policy that says all employees must be vaccinated, I'm not saying you are not performing. I'm looking at the policy on its own. It's a contravention of a policy. So sometimes employers can take that route. Never underestimate that. A practical example, Advocate. If you get arrested, you are sentenced, the employer now wants to dismiss you. He can't retrench you because you can't be replaced. Job is not redundant. He can't say it's misconduct because you haven't broken any rule at work. You are arrested for traffic fines, and for 2 weeks you are there. It has nothing to do with work. He can't say you're not performing. But remember, in labor law, there's something which is also called impossibility of performance. Impossibility of performance. We have done a risk assessment in this workplace. After doing a risk assessment, we've identified that these roles cannot be performed unless you are vaccinated because it pushes you at risk. It's impossible to do this role unless you're vaccinated. So sometimes employers, they are using the route of impossibility of performance. We are working in a mine. In the mine, we can't wear masks because it's too hot. We have to breathe. In the mine, the job we do, there's no social distancing. In the mine, we can't put cans of sanitizers. The nature of that job, we can't implement any protective measures. You can't wear masks, you can't have social distancing, you can't sanitize, we are underground, there is limited water, you can't wash hands all the time. In that instance, let's say the employer now says mandatory vaccination and you don't want to do it. And the employer now says it's impossible for you to do this job. An impossibility of performance because it's no fault. Sometimes people they classify it as incapacity. So remember, under incapacity, also advocate, it's not limited to ill health, injury. Sometimes under incapacity, you have incompatibility. People who don't fit in because of their personality traits at work. So incapacity is a big umbrella, and I think people can be able to squeeze in impossibility of performance within that, But it depends on how the people approach the case.
All right.
With all that said, I think that's the last question, advocate. Isn't it?
Yeah. Thank you very much. I think that is the last question. Once again, thank you very much for your time and your presentation. And we have seen that, like you have said, this is a packed session. We can have a second session on next week on Thursday so that you can continue and finish off where you have started. But on behalf of the South African Bar Association, thank you very much for availing yourself and for your presentation. We shall continue next week Thursday. Thank you very much.
Thank you, advocate. Everyone, thank you for having me. I will see you next week, same time. Enjoy the rest of your evening. I'm excusing myself. Thank you so much.
Thanks.